Okay, our topic today. The name of our topic, sources of law. Sources of law. I think you heard something about the sources of law in your lecture in Ukrainian language. And I'm sure that you know something already about sources of law. But of course, I should give you some material in English. So, sources of law. Questions. Our questions today. First question will be about classification of sources of law. Classification of sources of law. Then I will go to the next question, to the second question, and this question will be about customs. Customs. Then, third question will be about legislation. Legislation. Then we'll speak about precedent. Next question, fifth question, about treaty. Then, of course, we should speak about religious books. And our last question, seventh question, will be about books of authority and treaties. Books of authority and treaties. I hope you heard our plan. And we can start. So, an important aspect of any legal system is its sources of law. There are numerous ways of classifying sources, and the term source of law refers to, for example, immediate or direct of the law, which means the sovereign in the country. Yeah, why not? Then another meaning of the source of law. We can understand it's like a historical document from which the body of law can be known. Yeah, maybe you know some examples of these historical documents. Then another understanding, historical law can be like causes that have brought into existence the rules that later on acquire the force of law. And last understanding of the source of law, it's like instrument. I mean instruments by which legal rules are created. Yeah, they are the gates through which new principles find admittance into the realm of law. For example, it can be legislation, precedent, customary law, treatises, etc. In a nutshell, we distinguish formal sources, historical sources, legal sources, literary sources of law, and I think it's enough. Maybe you know some examples of formal sources or historical sources of law. Don't you remember something? Students, are you here?
Yes.
Yes, perfect.
Yes, we're here.
And I asked something. Don't you remember something historical sources? Some examples, no?
Maybe doctrines, for example.
Doctrines? I'm not sure, but maybe if this doctrine was from ancient Rome, for example, yeah, or
Maybe
yeah, please. Yeah.
archaeological things.
Okay.
Археологічні знахідки, речі.
Archaeological. Maybe you are right, but I asked about some sources in the sphere of jurisprudence. I mean, for example, maybe you remember in England, we know the common law. Yeah, the law merchant, Roman law. Yeah, as you know, now you are studying. Yeah, the Roman law.
Yes.
It can be like historical sources. Because historical sources are the historical origins and development of different rules of law deriving from separate sources. Something like this. I hope you can understand this. Then, what about formal sources? Formal sources are the sources from which a legal system ultimately derives its validity and effect. For example, a prominent English jurist, John Austin, I said about this English jurist at our previous lectures, he saw laws as the commons of a sovereign. I hope you remember this definition of law, yeah? To whom a habit of obedience is owned, which are enforced by sanction. Yeah, and other thinkers consider social relations as the main source of law. Yeah, something like this. Then another ideas about sources, it's legal sources. Yeah, legal sources. I think you know what is legal sources, and we can give some definition to these legal sources. And legal sources are the authorities for existing rules of law. For example, it can be some legislation or a custom or a case law. The comparative importance of these matters has varied greatly over the last 1,000 years. Custom now has a very minor role to play in the law, though it was of prime importance before the development of the common law. And another source or sources are literary sources. Literary sources. What is this? Literary sources are written, yeah, are written records of legal rules, such as, for example, statutes, yeah, or law reports, and to a lesser extent, legal textbooks. But probably the most important division, if you remember, is primary sources and secondary sources of law. Yeah, for example, 2 primary sources and 2 secondary sources of English law must be mentioned. And these primary sources are legislation and the judicial precedent. And the secondary sources are custom and books of authority. Okay, if you don't have any question, we'll go to the second question. And we'll speak about custom. Don't you have any question?
No.
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 Not really.
Thank you. So, custom. What should we know about legal custom? Legal custom is a social habit that is admitted by the state. It's not a custom in the whole sense. Yeah, it's not a folkways or mores. Yeah, it's legal custom. Legal custom. Legal custom should be considered as an original base of law. And many of the fundamental rules of the UK Constitution are customary. I think you heard something about this. And so-called standing orders, or in other words, an instruction or prescribed procedure that guide routine work of the parliament are customary. And examples of constitutional customs, judges don't take an active part in political life. I hope you heard, yeah, about this custom. Then another example, members of parliament shouldn't criticize the judiciary. Or, for example, the monarch doesn't visit the parliament. It's custom. Nowadays, most general customs are not current or have become absorbed in legislation or judicial precedent. For example, many of the early rules of the common law were general customs adopted by courts. By the act of adoption, customs were transformed into law. So too, much of the modern merchant law, it originated to general customs of merchant, which the courts had adopted during the course of the 17th and 18th century. And indeed, they are still assimilating international banking practice. And many rules of the law relating to the sale of goods originated as customs, were adopted by the courts and eventually transformed into a statute code, for example, by the Sale of Goods Act. I mean, in the UK. So, on the other hand, customs prevailing among particular groups of people living in particular localities are sometimes still recognized by the courts as capable of creating a special law for the locality in question and variance with the general law of land. And of course, here I should say about some features. Yeah, so the following features are among the more important of those conditions. Firstly, now we'll speak about the features of the legal customs. Yeah. Firstly, we should say about immemorial prescription. Immemorial prescription. What is this? It must have existed in fact or by presumption years and years ago, since time immemorial. For example, in England, the custom must be shown to have existed since 1189. the time fixed by the Statute of Westminster. In some cases, it is sufficient to raise a presumption of antiquity, for example, by showing that a continuous customary user has excited for as long as living memory can go. Of course, such a presumption is open to rebuttal, such as by evidence indicating that the custom began after 1189. Then, next feature of the legal customs is local circulation. Local circulation. What is this? The custom must be local. That is confined to a particular locality. These local customary laws were not written down and were administered by the local courts. And again, for instance, maybe you heard, but maybe no, it was some case, and in the case Mercer versus Dan, it was in 1905. The fisherman of Volmer, this is the town in the district of Dover, Kent. The fishermen of Volmer were entitled, by reason of a local custom, to a special right to dry their nets upon a particular beach. The owner of this beach was going to build houses on part of his beach. But the local fishermen established ancient rights to dry nets on this place and prevented building. The court affirmed their right to use this place according to the ancient custom. I think it's an interesting example. Next feature, the custom must be reasonable. It mustn't be repugnant to any fundamental principle of justice. And then, next feature, the custom must be clear, must be certain. It must be applicable to all cases where a custom is suggested as the basis of rights. A custom must be certain as to its general nature, as to the persons alleged to be affected, as to the locality in which it is alleged to be affected. For example, town, parish, or country, or manor, something like this. Okay, the fifth feature of the legal customs, the custom must be obligatory. Unless the custom doesn't carry with it obligatory force, it will not be upheld, since in that case it doesn't have the characteristics or characteristic of a rule of law. Next feature, the customs must have been exercised peaceably, openly, and as of right. Next feature, the custom mustn't have been interrupted. To be valid, a custom must have existed without interruption since time immemorial. A mere lack of use for a period doesn't necessarily mean that the custom has been extinguished, though it makes it more difficult to establish. So provided that the requirements stated above have been fulfilled, it is unnecessary to prove how the custom originated. So in the modern law, custom has a very limited role to play and a narrower meaning. That is a particular rule which has existed since time immemorial and must have obtained legal status within a particular location. It is very unusual for a new custom to be considered by the courts today, and even rarer for the courts to decide that it will be recognized as a valid custom. But there have been some such cases. For example, and it's a very interesting and famous example. It was some case, and in case New Windsor Corporation versus Meller. It was in 1974. A local authority was prevented from building on land because the local people proved that was a custom that they had the right to use land for lawful sports since 10th century. And modern legal system generally recognized customary rules that have emerged either within the confines of positive legislation or in areas that are not disciplined by positive law, and where a custom is in direct conflict with legislation, the latter normally prevails. I think you know about these moments, but we shouldn't forget about the importance of legal customs. If you don't have any questions, I think we can go to the next question with the name legislation. Yeah?
Yes.
Okay, legislation. What is this? I think you know what is this, but I should say a few words, of course, about legislation. So nowadays, legislation or acts of legislative bodies, or another name, statutes, legislation are considered as the main source of almost all national legal systems. I think you can agree, but maybe not. We will discuss. The practice of countries with different legal traditions shows the increase in the number of acts of the legislative bodies. Laws form the basis of the modern legal system. Laws have superior, after constitution, of course, legal force. The constitution is often called the supreme law of the land. That means no law in the country can violate the rules, laws, and rights set forth in the constitution. The reason of the strengthening of the position of the legislation is in democratic character of the procedure of adoption. In acts of the legislative bodies, the people's will is transferred into the will of the state. And they are the result of the certain political compromise of different social and political interests. For the reaching of a compromise, the special legislative process is established. It is open for public, mass media, so it is under social control. So the term legislation, or we can use another term, for example, statutory law, may refer to a single law or the collective body of enacted law, while statute is also used to refer to a single law. Legislation is usually proposed by a member of the legislature, for example, a member of Congress or a member of parliament, or by the executive power. It is debated by members of the legislature and is often amended before passage. Most large legislatures enact only a small fraction of the bills proposed in a given session. Whether a given bill will be proposed and enter into force is generally a matter of the legislative priorities of government. The act of making legislation is sometimes known as legislating. Under the doctrine of separation of power, I think you remember this doctrine of separation of power. The lawmaking function is primarily the responsibility of legislature. However, there are situations where legislation is enacted by other means, and most commonly when constitutional law is enacted. These other forms of lawmaking include referendums and constitutional conventions, and the legislation made by a parliament is called primary legislation. So the legislation made by parliament is called primary legislation. Though the laws are adopted by the legislative body, other governmental bodies also take part in this process. The executive and legislative power take part in the making of a law. The government introduces the greater part of bills and control the legislative process to a greater or less degree. The head of the state may sign an act or use the right of veto. The adopted law may be checked for constitutionality by the judicial power. So if a law is in force, it means that all state powers agree with its content. The lawmaking of the legislative acts is controlled by the state to a higher degree than the lawmaking of other sources. Yes, here we can see some process of working of these three parts of the power. Yeah. Okay, I mean legislative, executive, and judiciary powers. So next moment, very important moment, and I want to say about the delegated legislation. Delegated legislation, something secondary, yeah, secondary legislation, or if you want, you can use subordinate legislation. The word subordinate legislation. So delegated legislation is law made by an executive authority on the powers given to them by primary legislation in order to implement and administer the requirements of the act. So delegated legislation can take several forms. The most important form is a statutory instrument. The statutory instrument will contain a preamble which sets out the authority under which it was passed. It will also contain a statutory note which sets out its purpose and its scope. Statutory instruments are made in the name of a minister, but are drawn up by the legal department of the relevant ministry. Another form in the United Kingdom is called orders in council and made by the Privy Council. Privy Council. The Privy Council is made up of eminent parliamentarians, yeah, it will be better to say, and the government. The Privy Council can introduce legislation without going through the process of enacting a statute. Orders in council can be used to implement emergency legislation where there would not be time to have formal debate in the Houses of Parliament. Then I should say about such words like bylaws. Bylaws made by local authorities and other public bodies are another type. They are used to introduce local rules of minor importance. And the power to enact bylaws is given by an enabling act, such as the Local Government Act in the UK, something like this. And delegated legislation has certain advantages and, of course, disadvantages. The advantages are that it can be enacted without using up parliamentary time. That's why it is flexible enough to deal speedily with changing circumstances and emergencies. And delegated legislation is also criticized, and we can see some disadvantages of delegated legislation. First, there is the danger that the government can pass legislation setting out new principles by abusing the process of delegated legislation. And second moment, some delegated legislation gives ministers the power to alter statutes, possibly including the very enabling act which conferred the power to make the delegated legislation in question. Okay, I think you heard something new about legislation, and now you can say something about delegated legislation, some advantages and disadvantages of this type of the sources of law. Next question about precedent. I think it's an interesting question, and you can hear something new about the precedent too. Oh, maybe you remember what is precedent or not? Legal precedent or judicial precedent?
Yes, quite. I quite do remember.
Okay, and what is this?
Judicial precedent is a decision of a specially authorized body that has a power of a law.
It's this.
Basically a court, especially a court, but it can be, I think, not only court, but
Is decision, and then we can take this decision and
use it as a law.
yeah, use it as a law. And okay, precedent is a judgment or a decision, like you say, yeah, by a court and taken by a court in some previous case, which would form a basis of all similar cases in the future. Yeah.
Yes, quite.
Thank you. So, in common law legal systems, a precedent is a legal case establishing a principle or rule that a court or the other judicial body adopts when deciding subsequent cases with similar issues or facts. I should say about some example. I think it will be interesting. For example, it was some case, the case of Donahue versus Stevenson. It was in 1932. Mrs. Donahue went to a cafe with a friend. The friend brought her a bottle of ginger beer and an ice cream. Ginger beer and ice cream. The ginger beer came in an opaque bottle, so that the contents couldn't be seen. Mrs. Donahue poured half the content of the bottle over her ice cream and also drank some from the bottle. After eating part of the ice cream, she then poured the remaining contents of the bottle over the ice cream, and a decomposed snail emerged from the bottle. Mrs. Donahue suffered personal injury as a result. She commenced a claim against the manufacturer of the ginger beer, and her claim was successful. And the House of Lords held that a manufacturer owed a duty of care to the ultimate consumer of the product. It was some precedent. And precedent is central to legal analysis and ruling in common law countries like England and the United States, or you can use here another term and said not about the common law, but English American law. Yeah, or Anglo-American legal system. Yeah, Anglo-American legal system. In civil law and pluralist systems, as under Scots law, precedent is not binding, but case law is taken into account by the courts. And another example, another case. It was in 1966 in the USA. It was the case Miranda versus Arizona. Ernesto Miranda was arrested for the kidnapping and rape of a young woman. Upon arrest, Miranda was questioned for 2 hours. He never asked for a lawyer and eventually confessed to the crime. Later, however, a lawyer representing Miranda appealed the case to the Supreme Court, claiming that Miranda's rights had been violated. Miranda was acquitted. The court ruled that citizens must be informed of their rights prior to questioning. Any evidence or statement obtained prior to a suspect being read his or her rights is inadmissible. This has led to what is commonly referred to as one's Miranda rights, having to be read upon questioning or arrest. They are, maybe you remember, and you saw this in some films. They are, you have right to remain silent. Anything you say can and will be used against you in a court of law. You have right to an attorney. If you cannot afford one, or one will be appointed for you. Note, Miranda was later killed in a barroom brawl, but it was another story. So, the precedent that must be applied or followed is known as binding precedent. Binding precedent. It's alternatively mandatory precedent, mandatory or binding precedent, etc. Under the doctrine of stare decisis, a lower court must honor findings of law made by a higher court. Decisions of lower courts are not binding on each other or any courts higher in the system, nor are appeals court decisions binding on each other or on local courts that fall under a different appeals court. Further, courts must follow their own proclamations of law made earlier on other cases and honor ruling made by other courts in disputes among the parties before them pertaining to the same patterns of fact or events, unless they have a strong reason to change this ruling. Then I have material about some types of the precedent, and I don't know even should I speak about these examples or not, because maybe I will not have enough time for this. Maybe I'll say something of this doctrine, stare decisis, or I think it will be better to speak about the structure of the judicial precedent. And these structural elements have some special names. Okay, the structure of a judicial precedent includes two elements: ratio decidendi and obiter dictum. It's in Latin. The dictionary meaning of this Latin expression is the rule of law on which a judicial decision is made, or reason for deciding. And every decision has three basic postulates. First postulate, findings of fact, both direct and inferential. Second postulate, statement of principles applicable to the legal problems as disclosed by facts. And third postulate, judgment based on the combined effect of the above. And to consider to the ratio decidendi of a case, the court has to ascertain the principle upon which it was decided. This is sometimes difficult in cases where divergent views are expressed by different judges, but eventually the final decision is taken. A decision is binding not because of its conclusion, but in regard to its ratio and the principle laid down therein. General statements made beyond the ratio decidendi have mere persuasive value only. Although the ratio decidendi can be applied to similar on basis of fact and law, the court has said that care must be taken to ensure that it is not implied mechanically, And another part is obiter dicta. Obiter dicta is a judge, or it's judges' expressions of opinion uttered in court or while giving judgment, but not essential to the decision and not part of the ratio decidendi. It also means an incidental remark or something that is in passing. The obiter dicta is things stated in the course of a judgment which are not necessary for the decision. And again, a little example. It was the case, and it was in 1987. It was some participant with the name R, yeah, and Ho and Bannister. Ho and Bannister, Ho and Bailey, yeah, I'll read in the right way. Both age 18 and Bannister aged 20 were acting under orders of Murray, aged 35. The charges related to 2 murders and 1 conspiracy to murder. The House of Lords held that the defense of duress was not available to murder. This was the ratio decidendi of the case, and the House of Lords went on to consider whether the defense should be available to those who attempt murder and stated obiter dicta, and that the defense of duress shouldn't be available to attempted murder. And normally, even an obiter dictum is expressed, not expressed, expected, yeah, to be obeyed and followed. The obiter dicta of the Supreme Court are entitled to considerable weight. However, the weight accorded to obiter dicta varies with the type of dictum. Mere casual expressions carry no weight at all. Not every passing expressions of judge, no matter how eminent, cannot be treated as having the weight of authority. In some cases, the obiter dicta of the court will have mere recommendatory effect, and the government or parties to the case are not bound by them. I think it's enough interesting information, and in reaching decisions, courts sometimes quote passages of obiter dicta found in the text of the opinions from prior cases, with or without acknowledging the quoted passage's status as obiter dicta. Quoted passage of obiter dicta may become part of the holding of ruling in a subsequent case, depending on what the latter court actually decided and how that court treated the principle embodied in the quoted passage. Okay, maybe this information was a bit difficult for understanding, but of course I'll send to you the material, and maybe it will be better to understand these all ideas. Now, I think we can go to the next question, and next question will be about treaties. Yeah, treaties or treaty. Do you know what is this treaty?
Соглашение.
Yeah, you are right. It's some agreement, yeah, between states, whereby the states participating bind themselves legally to act in a particular relation between themselves. Yeah, so treaties thus signify a written instrument in which the participants, usually but not always states, agree to be bound by the negotiated terms. Treaties are divided into lawmaking treaties, treaty contracts, and so on. Maybe we can speak about international or treaties as a source of international law. Why not? Maybe you know some examples. So what is the lawmaking treaties? Lawmaking treaties, these are multilateral treaties and mainly intend to have universal or general relevance. What is a treaty contract? Treaty contracts, these treaties apply only between or a small number of states. They are namely bilateral treaties. Bilateral treaties. Treaties express agreement and are a form of substitute legislation undertaken by states. Treaties, as of I said about this moment, you can understand treaties as a source of international law. And the treaties as a source of international law originates from mainly the lawmaking treaties, which are intended to have a general effect. The law-making treaties are those agreements whereby states elaborate their perception of international law upon any given topic, or establish new rules are to guide them from for the future in the international conduct. These are multilateral treaties and may produce rules that bind all states irrespective to their consent. However, where treaties reflect customary law, then non-parties are bound, not because it is a treaty provision, but because it reaffirms a rule or rules of customary international law. I should say that treaties are codified, making it easy to refer and address a wide range of issues. And examples are the laws of the European Union, trade treaties, rules of the World Trade Organization, and bilateral treaties too. So rules and guidelines may also be imported into law through treaty in relation to such matters as standards of engineering and health guidelines. For example, a country may adopt the World Health Organization standards for drinking water. For example, like this. Okay, maybe when you will do some preparation for the next seminar, you'll read more information about treaties, but now we'll go to the next question, and our next question, as you remember, was religious books. Yeah, religious books. We discussed at our seminar today what is religion. Yeah, and it was like a norm of the regulator of the legal, and not only legal but social relation. And now we should speak about religious books as a source of law. So all religions have sets of codified laws. For example, Islamic law is based upon four main sources. The Quran, yeah, I think you remember this name of the main book from this religion, from this law, Islamic law. It's Muslims believe the Quran to be the direct words of Allah, as revealed to and transmitted by the Prophet Muhammad. Yeah, am I right with this pronunciation or not? Don't remember.
You're right.
Yeah. Oh, thank you. Thank you. Just I'm not sure. But okay, the Quran is therefore regarded as the definitive authority on matters of Islamic law and practice. When the Quran itself doesn't speak directly or in detail about this certain subject, only then do Muslims turn to alternative sources of Islamic law. And all sources of Islamic law must be in essential agreement with the Quran, the most fundamental source of Islamic knowledge. And here I want to say about another sources and another name of the religious book, the Sunnah. The Sunnah is documents or writings documenting the traditions or known practices of the Prophet Muhammad. The resources include many things that he said, did, or agreed to, mostly based on life and practice based entirely on the words and principles of the Quran. During his lifetime, the Prophet's family and companions observed him and shared with others exactly what they had seen in his words and behaviors. In other words, how he performed ablutions, how he prayed, and how he performed many other acts or worship. It was also common for people to ask the Prophet directly for legal rulings on various matters. When he passed judgment on such matters, all of these details were recorded, and they were used for reference in future legal rulings. Many issues concerning personal conduct, of course, community and family relations, political matters, and etc. And these many issues were addressed during the time of the Prophet, decided by him and recorded. And the Sunnah can thus serve to clarify details of what is stated generally in the Quran, making its laws applicable to real life situations. And here I want to say another source, and the name of this source, Ejma. In Ukrainian, Ijma. Ejma, it's like consensus. In situations when Muslims haven't been able to find a specific legal ruling in the Quran or Sunnah, the consensus of the community is sought, or at least the consensus of the legal scholars within the community. The Prophet Muhammad once said that his community, for example, the Muslim community, would never agree on an error. And another interesting, I think, source, and again, religion or religious book, it's Qiyas. Yeah, am I right with the pronunciation? I think yes. Qiyas. And we can understand this book as analogy. In cases when something needs a legal ruling but hasn't been clearly addressed in the other sources, judges may use the analogy, reasoning, and legal precedent to decide new case law. And this is often the case when a general principle can be applied to new situations. For example, when recent scientific evidence showed that tobacco smoking is hazardous to human health, Islamic authorities deduced that the Prophet Muhammad's words, "Don't harm yourself or others," could only indicate that smoking should be forbidden for Muslims. So it was only one example of some religious books, and of course here we can use another example. It can be Bible, yeah. We can speak about Torah and another religious books. Of course, here we can speak about Vedas from the Indian society, and yes, it will be interesting, and maybe in our future seminars we can speak about these religious books too. Then I think we can go to the last question. Yeah? And our last question, books of authority and treaties. Books of authority and treaties. And here, not be confused with treaties. Yeah, treatises. Yeah, and treaties. Yeah. Treatises are book length expositions on the law as it pertains to a particular subject. Treatises may be scholarly in nature, such as, for example, Blackstone's commentary on the law, Blackstone's commentaries on the law, or they may be geared toward the legal practitioners, such as a manual or handbook. Yeah, it's some books of authority. On the content of readings of legal authors form an important source of law. In England, in accordance with the tradition that the law is to be sought in judicial decisions, their writings have in the past been treated with comparatively little respect. They have been cited in court rather by way of evidence of what the law is then as independent sources from which it may be derived. This general rule has, however, always been subject to certain recognized exceptions, for there are certain books of authority written by authors of outstanding eminence, which may not only be cited as independent source in themselves for the law or their times, but which also carry a weight of authority almost equal to that of precedents. And among the most important of this work are Blackstone's, for example, De Legibus et Cons. I can't read even because it's in Latin, and it was in 13th century. Yeah, and of course, this Blackstone's commentary and Bracton's book were very important, and even now these books are very important, and the name of these books, the books of authority, and the court can use the ideas from these famous books like a legal precedent. In modern times, the established tradition appears to have been breaking down because many textbooks are now in practice constantly cited in the courts, though only the best of them are likely to command attention. And the reason to this departure from the established tradition is probably that in comparatively recent years, a large increase in the popularity of the study of English law in all our major universities has done much to improve the quality of legal writing and to increase the volume of legal literature. Thus, today, Salmon's law of torts is commonly referred to in court, and even works of living authors such as Smith and Hogan's criminal law are now often cited, though by rule of etiquette, counsel who refers to works of the latter category shouldn't cite them directly as authorities, but should request the leave of the court to adopt the arguments which they contain as part of his own submissions. In practice, however, even this latter etiquette is now not always observed. So some treaties are designed to serve as practitioners' tools. These works tend to address realistic legal problems and often provide useful feature for practicing lawyers, such as forms and tables. Okay, of course, we can speak in other sources of law, and here I can speak even about some legal myths. Yes, maybe it's surprisingly for you, but it's true. I can speak about such source of law. And now I think you are very, very tired. And we have a few minutes for questions. Please, if you want to ask me something, you can do it.
No, thank you. Everything is
I
clear.
don't have a question.
Yes, everything is clear.
Thank you very much. And again, I want to repeat that we can use this lecture for our first seminar at the next semester. And I think at the at the end of this semester, we can say to each other, thank you.
Thank you.
very
Yeah,
much.
thank you
Bye.
very much.
Thank you so
Bye.
much.
Thank you and see you later. Have a good day.
It was a pleasure. Yes, thank you.
Thank you.
Have
Bye.
a good day.
Goodbye.
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 Bye.